Do you see this as political signaling? Do you see this as being something which is opportunistic ahead of elections in the country? Or do you actually see this as being really uplifting? Because that number which Shadhan was talking about makes so many people eligible. Is this a true reservation?
Well, I've always maintained as the reservation is concerned, the manner which is practiced is essentially a political artifice. As far as the judgment is concerned, I feel, and I said it on earlier occasions too, the judgment is completely flawed. In fact, I have occasion to disagree with both the majority and minority because they concur that the basic structure is not violated. In my opinion, it is violated. The identity test is violated, but that is a different issue altogether. Dealing with the issue which you have raised, two things are important. One, the amendment is enabling. Now, in terms of the amendment, there is an office memorandum. You referred to the office memorandum when it mentioned the various criteria. You have correctly pointed out that as far as the criteria is concerned, the criteria is such as to make the entire exercise more or less a worthless one because the sweep would be so wide as to make the trickle down of the benefits almost non-existent because choosing amongst the different contenders will be almost an impossibility. And here a very important aspect has been missed also by the Supreme Court is if there is an entitlement to provide a measure, the choice of the measure should be preceded by some kind of study, some data, some facts on which it can actually be concluded that what the government proposes to do is in fact a legitimate mode of exercise of authority. Why is that important? Because the entitlement is to equality, the right is guaranteed to an individual. This is an exception. It is called an application of the right, but the point is that to the extent a community or a section's interest is examined, the right of an individual is infringed.
Correct.
Now, if the right is to be infringed and for a cause which has to be substantial, the basis has to be known. Because until the basis is known, the very principle which is being applied would be more or less ambiguous and nebulous. And the method of enforcement, in fact, the basis of enforcement itself would be lacking.
Sure.
The problem with this entire exercise is that we have this imaginary figure and we have got the attendant circumstances, a few square feet or square yards, and from where we get it, to what extent it will be relevant, and in how do you say that this will in fact impact entitlement or cause some kind of disability is completely unknown.
Yeah.
So even if the intention is right, the method of bringing it about is completely bereft of any sense or substance as to make it wholly arbitrary.